Based on the area codes, good afternoon, everybody, although it's good morning here on the West Coast for me. And welcome to this edition of Interactive Dialogue by Dorsey and Whitney. Those of you logging in will be proud to know that you're here in the inaugural edition of the Interactive Dialogue for the Agriculture, Food, Ag, and Cooperatives Practice Group for Dorsey and Whitney. And I'm going to give a little bit more overview of the Food, Ag, and Cooperatives Practice Group at Dorsey at the very end of the program. A couple of things just as we get going. First is if you are logging in next door to somebody who may not have phoned in to the audio portion and is wondering why their screens are silent, nudge them please and remind them to phone in to the 800 number that's listed there in red on the screen. Second, we've sent a sign-in sheet that was enclosed with the reminder email that was sent yesterday, Monday, April 18. That will include a sign-in sheet for you to get credit. I'll briefly mention that towards the end of the program as well. Finally, we will be taking chat-type questions, and you'll see in the bottom left-hand corner of your screen there's a little chat pane. And if you have any questions as we're going through the program today, then please just identify those. They'll come to me, and I will either ask them if it's not something we'd already planned on talking about, or I'll make sure and weave them into the program as we go along. If you'd like me to keep your name or company or the like confidential, then please just make some indication there that says confidential question, and I'm of course happy to accommodate that. Otherwise, I might mention a person's name who happens to ask a question. So, for example, Bridget Hayden, one of our partners, I see logged in. Thank you, Bridget. And if you had a question that you wanted to ask, then I might mention your name since you're somebody that I know. So, in any event, a little bit about the program here, and specifically the type of program. This format of doing a presentation really started by an idea that was raised through a longtime client of our Food, Agriculture, and Cooperatives Practice Group called Vegetable Grower Supply. And VGS is, as you would expect, a company that supplies products to the vegetable produce industry based in California, and they also have some locations in Arizona. And in giving a different type of presentation, I was on the phone with Jennifer Keegan from VGS, who mentioned that with today's busy schedules and the like, for them at least in Salinas, California, the ability to attend programs far away is very difficult, and frankly, sometimes even in your own hometown, it's hard to peel away and attend a legal program or any other kind for that matter. So she recommended that we produce these kinds of formats in a web-based system so that people could get access to that information. And as you may have heard, those who logged in really early will know that we're taping this program so that if you have a colleague who you think might benefit from this type of information, then you can ask us and we're happy to send you a link to the audio portion of the program, and they'll also see the web-based as well and be able to listen into the program also. So with no further ado, a little bit about myself and Thad Lightfoot. I'll start, Thad, if you don't mind giving my brief bio.
Sure.
I'm a partner in the Seattle office and also work in California, where I started practicing initially in San Jose, California, very near the salad basket of the world known as Salinas. And I have been working in the agriculture and cooperatives space over the last 25 years or thereabouts. I practice in two technical areas, one being corporate work for agriculture and cooperative type companies, and then also employment law for those and other kinds of companies as well. Based in the Seattle office, and glad to be one of the hosts for this program. Thad, could you give your background?
Sure, Mike. I'm a partner in Dorsey's office in Minneapolis in the Regulatory Affairs Group. I'm an environmental lawyer, which is really, fortunately for me, all I've done for my entire career, about 28 years or so. I was a Justice Department lawyer for a number of years out of the Washington, D.C. Main Justice Office in the Environmental Enforcement section, representing primarily EPA Region 5, and have been in Minnesota now for about 20 years or so. And I do, as I said, exclusively environmental, and represent a number of Dorsey's cooperative clients and agricultural entities on environmental and regulatory issues.
So I had to chuckle when you said, fortunately, you practice in the environmental regulatory area, because I thought the same thing. One of the things I love about Dorsey is that I'm fortunate to work with folks like you, so I don't have to be the one to figure out the law all on my own. I could just call that in case of emergency, at least in the environmental area. So today we want to have a different kind of format than many of the lawyer programs that you may have seen. Instead of having a large quantity of slides that we cram through in a short period of time on the internet, we'd rather have a dialogue, what we're calling an interactive dialogue on a particular topic. And we chose the area of this particular topic called muddy waters because of some changes that are happening in the legal world, and specifically things that affect agribusiness generally. Myself representing primarily co-ops, we're talking often the members, the farmer members of the cooperative, and also anyone who's involved in agriculture really needs to know more information about what's going on in the Clean Water Act. For myself, I'd say, why pick this topic? We've had some litigation out west here, in particular in Washington State, that have where creative plaintiffs' lawyers have used legal issues like the Clean Water Act to target farmers and farming generally to try to prevent either certain kinds of production from happening, or in addition to try and make kind of semi-political statements about what they view as appropriate practices in certain industries. It's an interesting aspect, and we'll talk a little bit about this, I know, Thad, later on, that there can generate a lot of attorney's fees as part of this litigation. And we've had some experiences here in Washington where, again, creative plaintiffs' lawyers have used the Clean Water Act and other state-based statutes to create a public advocacy group, then file litigation, use the settlements associated with that to fund essentially future challenges and the like. Thad, from your perspective, why is this an important topic for agribusiness to know?
Well, I think, Mike, one important aspect is what you just said, and what you were referring to are what are known as citizen suit provisions in the Clean Water Act, which allow citizen plaintiffs, to bring independent enforcement actions against agribusiness and other companies and recover their attorney's fees if they prevail. So that's certainly something that we'll talk a little bit more about, but is important to remember. But specifically, when we're talking about the Clean Water Act, there have been a lot of recent there's been a lot of recent case law and a lot of number of recent attempts at regulatory change, what EPA has called regulatory clarification of the Clean Water Act, dealing most precisely with the question of what constitutes a wetland that's regulated under federal law, and what agricultural activities regarding wetlands are allowed. It's a complex area. There have been some new rules, as I said, that EPA has promulgated. Those are now stayed. We'll talk about that in a few minutes. It is the single most controversial issue under the Act right now.
Now, when you say clarification, how many pages did it take the EPA to clarify this statute?
Well, that's hundreds. And by the way, the proposed rule generated over 1 million comments. Most of them were negative. So the agency killed a lot of trees in the name of clarification.
I love it. A classic legislative concept. Let's clarify by issuing hundreds of pages. All of which, of course, need further clarification, which is what I guess gives us lawyers work to do. So that's not a bad thing.
Right.
Now, can you give us some examples of the kinds of places where somebody could trip over the statute, in particular in agribusiness?
Right. Well, the question is when you think, wetlands are certainly one area that are regulated under the Act, and in particular, the statute requires, it doesn't say that you can't fill or drain a wetland, but it says that you have to get a permit first, and that obviously can be complicated. The problem arises in what's a wetland. I mean, classically, a wetland is a pond. It's standing or saturated soils. It's a marsh. It's something of that nature. It may be surrounded by cattails. What most people don't realize is that in and of there can be wetlands actually can be dry or can be dry for part of a year, and therein lies the problem. You can actually have land that is water or regulated as water under the Clean Water Act.
So when I think of a wetland, I usually think of something that generates a bunch of mosquitoes, right?
Well, we have those out here in Minnesota, certainly. That's right.
the state bird, as it were.
Right. That's right. But it's not just that. I mean, for example, you might have a lake, and then which is a classic wetland, and then something that is then beaches that are right next to that lake, and you might have a river that drains from the lake, and then that river drains to a stream, which drains to a smaller stream, and at some point things dry up, but that doesn't necessarily mean that you're safe to fill or to farm in that particular area.
So your story kind of reminds me of the old classic kids game of Operation, where the knee bone is connected to the hip bone, and the hip bone is connected to the leg bone or whatever. Is that kind of how it works with defining a wetland? You trace essentially all the way back?
Yeah, it's very much like that. And if you think of that old operation board, and then think of say another table next to that board. The table next to the board, if that area is completely unconnected, that's an area that would likely be known as an isolated wetland and wouldn't be regulated under the Clean Water Act. But everything that's sort of connected, the knee bone connected, everything on that operation board may well be a wetland that's regulated under the Water Act.
Is the definition of a wetland something that creates any bright line rules or tests that people can rely on?
There are some bright line rules, and the easiest rule, if you want to look at it, is if there's an area that is immediately adjacent to an area that is wet most of the year, that's going to be regulated. The problem is that once you move away from that, then the rules get a lot vaguer, or more vague. And then the question is there some sort of what the courts have talked about as a significant nexus? Is there some sort of relationship between that area, which is clearly regulated, and an area that might not be? When we think about, again, the lake going to the river, going to the stream might still be regulated, but if the stream then ends and there's water up a bank or a berm or a hill on the other side of that hill from the stream, the question is then, is that water part of that interconnected water system that would be regulated, and that's where some of the problem lies.
Is there any place that a person can go to find out whether their property has a wetland under the Clean Water Act or is near one?
Well, there are some places that you can go. The Fish and Wildlife Service has what's known as a national wetland inventory, which has wetland maps for the entire United States. The problem is that they are not comprehensive. So unfortunately, I mean, it would be easy to say, yes, there is. All you have to do is look in this particular area, and you know definitively whether you have a wetland. or a wetland that's, say, regulated under federal law, and don't forget about state and local law, more on that in a moment, but that federal wetland inventory, or national wetland inventory that the U.S. Fish and Wildlife Service has put together is not comprehensive. And just to give you an example, I had a client a few years ago that looked at the federal wetland inventory, had a wetland on his property. He looked at the federal wetland inventory. He called the United States Army Corps of Engineers, which has jurisdiction over federally regulated wetlands, and they said, no problem, don't worry about it, you're fine, you can fill that wetland. He talked to the Minnesota Department, this was in Minnesota, he talked to the Minnesota Department of Natural Resources, which actually has an excellent map. There's a separate state regulation here in Minnesota, and that wasn't on that map, and he confirmed with DNR that it was not, the Minnesota Department of Natural Resources, that it was not regulated. He then began filling the wetland. His neighbor, who didn't like him very much, called the county, and he ended up with a cease and desist order because Minnesota has a third program, which is a local program that he didn't know about. So it'd be nice to say that there was one-stop shopping. Unfortunately, there isn't.
You know, it's interesting you make the comment about the Hatfields and the McCoys, as it were. One of the things that I often think about is, what's the chances that you're wrong? And you've just described some of the areas that a person would need to go through in their own due diligence about whether this particular piece of property is or has part of it that is a wetland. And then the second is, what are the chances that someone will gripe about it? And often that can happen in the most benign ways. You get into a spat with a neighbor over a border dispute, or somebody decides to sell to a neighboring competitive co-op, and they don't like you for some reason. So things happen that can create risk that you don't anticipate. Why put this as one of the first slides in the program?
Well, because it's important to know what we're talking about before we talk a little more about the actual regulatory regime, because it's just not it's not intuitive. And the other important thing that the Clean Water Act does is protect wetlands, and as we say in the slide, why protect them? Why? I mean, I think a lot of agricultural companies and a lot of agricultural producers see them as an area that isn't productive, and that's true. They're not necessarily productive for agriculture, but Congress has made the determination to protect certain wetlands with some exemptions for agriculture, which we'll talk about in a few minutes. And it's because the wetlands address water quality and control water quality and can be helpful in flood control and provide habitat. There are, as well as recreational and and other amenities. And in fact, there are commercial benefits to wetlands. A number of wetlands are used to develop specialty products, including peat mining, for example. So Congress made a distinct, in the Clean Water Act, Congress made a distinct decision, or a conscious decision, to protect these areas for a reason.
So I have a couple takeaways before we move to the next slide, and that is that I just want to make sure I'm hearing this correctly. First is that I need to look at whether I have a wetland on property, and if I do, then the Clean Water Act would apply. If I don't, then it's one of those seminal questions on statutory coverage, right? Right.
Well, and the Clean Water Act might apply or it might not. Right. That's where you get to the question of is it what's known as is it a water that is a jurisdictional water under the Clean Water Act? Is it a water of the United States, which we'll talk about just in a few moments. If it isn't, and not all wetlands are, then there isn't a Clean Water Act then it's not protected by the Clean Water Act. But as I said before, there may well, that doesn't mean that you're necessarily in the clear to drain or fill that wetland. There may be state programs that protect it. There may be local programs that protect it. There are in Minnesota, and there are in a number of other states.
So my second takeaway is, in this kind of classic irony, the land doesn't need to be wet to be a wetland.
Correct.
Okay.
I know. I know. We're in Alice in Wonderland area here, Mike, but that's absolutely right.
All right. So can you just give a brief summary of how the idea of regulating waterways started and
Sure.
who pushed it?
Sure. Well, the regulation of waterways goes all the way back to the Rivers and Harbors Act of 1899, and that was Congress enacted that statute and put the U.S. Army Corps of Engineers in charge of that regulation. But that wasn't a water quality statute. It was a statute that dealt with navigation and was really designed to allow the Corps to make sure that waters became navigable. But there were certain definitions of what navigable waters were in the Rivers and Harbors Act, and typically it was a high water mark on a riverbank. The Clean Water Act came along in 1972 with the goal, as the slide said, to make all waters fishable and swimmable by 1983. That didn't happen, but the Water Act has done a great deal in terms of maintaining water quality in the United States. There are really two major programs under the Clean Water Act. One is, as the slide says, it's a program to deal. It's a permit program for dealing with the discharge of pollutants from think of it as a point source, the end of a pipe, into waters of the United States, into waters that are regulated under the Clean Water Act. The second one, and the one we're going to spend a fair more time talking about in this discussion, is the program that requires a permit to place dredge and fill material in the waters of the United States. And that's really what we're talking about when we're talking about draining a wetland or filling a wetland. That's a separate permit program. The point source program is run exclusively by the Environmental Protection Agency. The wetland program is run by the Army Corps of Engineers with the Environmental Protection Agency providing input.
So a couple of takeaways here, it seems. First is that the Army Corps of Engineers, you mentioned that a couple times, and it sounds like that really comes from the 1800s era law.
It does.
Over the issue?
It does. That's right. It's historic jurisdiction, and really that's why Congress kept the Corps involved in the wetland permitting program, given their historic dredge and fill activities.
Then the second observation I noted just on the slide here is that it sounds like if you need to do something in regards to one of these waters of the United States, which we'll get to in a second, you might be able to, but you just need to get a permit first. Is that right?
Correct. That's exactly right. It's not an absolute prohibition by any stretch, but it is a permit program designed to protect the waters of the United States. Now, what the permit, and without getting into too much detail, permits can be expensive to obtain, and they also, at least with respect to wetlands, don't simply allow you to fill a wetland. You have to fill a wetland, but you also have to propose and have the Corps agree to replace that wetland. So there is a wetland replacement plan that's part of the permit. So if you're filling a couple of acres of wetland, the Corps may require you to create 4 acres of wetland to replace those 2 acres that you're filling. And typically, the Army Corps would like to see that in the same area, in the same watershed, and have it replaced by the same quality of wetland, the same quality of water.
So this would be like a city that requires the developer to build a elementary school as part of the overall development, that kind of thing?
Right, exactly. I mean, there's some, because the idea is that you're removing a water of the United States from you're filling it. You need to replace that water.
So obviously, we're talking here about the federal statute, but you've mentioned a couple times about state and local regulations. Is there any generality you can make about the states? So, for example, as the land of 10,000 lakes, you would tend to have more regulation, but if you... Well,
we do, yeah. There are general... Actually, we have about... the 10,000 lakes is what you see on the license plate, but there are about 15,000 lakes that are 10 acres or more in the state of Minnesota. So, but in general, I think the more water you have in a particular state, the more likely it is you are to have state regulatory programs and local regulatory programs. That's the case in Minnesota. That's the case in a few other states that have a great deal of water bodies in the upper Midwest. So I think that's generally correct.
All right. So you've mentioned this phrase, water of the United States, a couple of different times. Can you give some examples of what that means, in particular from an agricultural perspective?
Sure. Well, it's unfortunately the statute defines waters of the United States in a somewhat circular fashion. It goes back to the concept of navigable waters back to the Rivers and Harbors Act of 1899, but it then essentially defines waters of the United States as navigable waters without really talking about what those navigable waters were or are. So don't think of a water of the United States as something that actually requires you to float a boat on it. It doesn't necessarily have to be a lake. It's an area that just has to have some hydrological connection to that lake, and it could be something. It could be a connection that is as ephemeral as a stream that runs a few months a year and makes an area that ultimately to which that stream drains from a lake, from a navigable water. That's an area that still could be a water of the United States. And if it happens to be on farm property, there are some exemptions for farming, but which we'll talk about in a moment. But if it happens to be on a farm property, then the Clean Water Act is going to apply absent statutory exemptions.
So you use this phrase hydrological connection, which I had to kind of bend my mind around here for a second. And I thought, does that include things underground as well as above ground?
It can. I mean, by hydrological, we're just talking about a water connection. And one of the things that we always look for in determining whether or not you have a water of the United States is what do the facts look like in terms of the water? What are the hydrological facts, if you want to call it that? There have been some in the Corps and elsewhere who have argued that a groundwater connection is sufficient. In most cases, it isn't, but it is something to be concerned about. But as I said before, you're looking not necessarily at an area that is wet all the time. You could have a stream that is wet just a few weeks or a few months out of the year, but that could be enough depending upon the analysis of the Corps under the Clean Water Act. Got it.
And you have a couple of references to Supreme Court decisions.
Right.
What are those?
Right. And just without getting into a lot of gory details, so the Water Act defined, as we discussed on the slide, the Water Act defines waters of the United States in a somewhat circular fashion. But what Congress specifically said in legislative history to the Water Act was they wanted the term waters of the United States to be read as broadly as possible. The Army Corps of Engineers, so the Clean Water Act was passed in 1972. The Army Corps of Engineers initially looked at that and looked at its jurisdiction quite narrowly. And then back to the question of citizen suits, of groups suing, they were sued by a number of environmental groups who said, no, you need to read your jurisdiction more broadly. And ultimately, courts agreed. And so from the mid-'70s until the early '90s, they read their jurisdiction quite broadly. Then the courts began to get involved, and the Supreme Court began to get involved more specifically. And in the early 2000s, there was a case where the Supreme Court said, we're not going to allow you, Corps, to exercise jurisdiction over what is essentially a prairie pothole. What's a wetland that was in the middle of nowhere and not connected to any other navigable water. And that was the first of a series of cases that reined in the Corps' jurisdiction. and created some question about what these what the Corps' jurisdiction was. And so then there was another case in the mid-2000s that said, okay, well, if you've got an area that's next to a wetland, that's clearly regulated. If you have an area that isn't connected to anything, that's not regulated. The hard part is in the middle, and that's where courts and EPA have struggled with trying to clarify just where that jurisdiction is.
And is that the rulemaking that's identified here?
There was a rulemaking in 2015, and yes, there was a rulemaking that a rule that EPA promulgated. Actually, this is the rule that I mentioned that was when it was published in 2014 generated 1 million comments. EPA promulgated the rule as a final rule in 2015. A lot of litigation followed. That was in the spring last fall, and that rule is now stayed nationwide. So EPA cannot enforce its rule that is attempting to clarify these issues. And we're kind of back to the status quo pre-rule, at least for now.
A long and painful route along those navigable waters, as it
Yes, a long and it's not over yet.
We've talked a little bit about what is the water of the United States, and you've mentioned a couple times that there are some exemptions for farming. Can you give a brief summary of what the exemptions are and what they exempt you from?
Sure. There are exemptions for farming. They are written into the statute. They're also expanded upon or clarified, to use that term in air quotes, I guess, in regulation. But they are specifically in the statute. The statute exempts normal farming, silviculture, and ranching activities. It also exempts certain constructions of ponds, irrigation ditches, and drainage ditches.
So before you go any farther, and mostly because I had to look it up myself, what the heck is a silviculture?
Think of forestry, Mike. It's the practice of controlling the growth and the health of forests. That's what it's all about.
So the forest and the trees, they're all covered.
The trees, the farm, and the ranch, right.
Got it. And you said that these are baked into the statute, right?
They are written into the statute. There are also some description or discussion of the rule or of the exemptions in regulations, but unfortunately the regulations don't provide a lot of definition or a lot of additional clarity beyond the statute.
So if I'm an agricultural employer, how do I determine whether one of these exemptions might apply to my farm?
Well, I think it's unlike some areas of agriculture where there's a definition for agricultural producer or there's a specific corporate distinction. The important focus under the Clean Water Act and the regulations is not necessarily on the type or the size of the organization, it's on the activity. So that's really the focus. So if you are doing what normal farming, for example, includes plowing, seeding, cultivating, minor drainage, harvesting, those types of things. You know, whether you're a family farm or whether you're a large corporate entity, if you're doing those activities, you'll be exempt.
Now, a couple of thoughts or questions. One is that this sounds like it does not apply, these exemptions do not apply if I'm in the agriculture business but not actually engaging in farming activities, right?
That's right. I mean, it really, because what it's doing, I mean, that's right. The activity is designed to ensure that, and if you think of dredge materials, soil, so to ensure that materials that are falling into wetlands that occur as a function of farming activities in the exemptions don't require a permit. But right, if you're simply an agricultural entity and you decide to go out and develop a particular area of land and you want to fill a wetland, and it's not for the purposes or the operation of farming, the exemption is not going to apply.
So, for example, let's say that I'm in the business of ranching, and I decide to put up a processing facility. Is that processing facility going to be covered by the exemption?
Probably not. And again, the regulations aren't crystal clear, but it's likely that that sort of development isn't going to be seen as a ranching activity.
So one of the questions that I kept thinking about as I was trying to figure out what these exemptions work is, how do you deal with incidental activities? Like, let's say that I'm doing farming but some other things on the land, or I'm primarily doing other things on the land but also do some farming of segments of it and the like. Are they looking just at what's happening on this physical piece of property? So first we decide this thing is a wetland, yes or no. If yes, then is what's happening on this wetland a normal farming activity, yes or no? And then if yes, then there might be an exemption. If no, then it's covered.
Right. So that's right. And I think if you had, if you had something that was if you had activities that were incidental to normal farming or dealing with the health of forests, silviculture, or activities that were or ranch activities where you were dealing with the manipulation of the land that caused material that caused a wetland to be drained, or that caused material to be discharged into the wetland, that would be exempt. So but the question is, and again, the agency is going to look at reasonableness, I think, and how far removed is that quote unquote incidental activity from the normal farming activity.
So a couple other questions as far as thinking about these exemptions. If I've got a farming activity that I'm doing and I decide I'm going to drain a wetland so that I can raise cattle on that land, for example, which I'm assuming would be a ranching activity, then a couple years in I decide that's not really an efficient use of that particular piece of land, and I decide to develop it doing something other than a farming activity. Is the fact that it was used for that period of time something that I could still have an exemption for having drained it?
Well, I think so, because at that point the wetland is drained, and it was drained as a result of a ranching activity, or it was drained as a result of an exempt activity, and so it's not. I would argue that it's not a wetland anymore at that point, and that it was perfectly appropriate for you to be able to drain that wetland or to fill that wetland because it was related to a ranching activity. Now, I suppose an environmental group or a regulator might look at how long you were involved in the ranching activity and how closely a development, for example, followed. If you said, well, this is a ranch activity or this is a farming activity, and you farm it for a month and then decide to redevelop the property, that may be a problem. But if it's a legitimate action that would fall within the exemption, then I think if a few years down the road that the land use changed, I don't think that you would have a problem under the Clean Water Act.
Now, you've raised something here called the WOTUS rule. I'm assuming that means
that's the rule what we talked about, the waters of the United States rule. This is the rule that I mentioned that was promulgated in That's what WOTUS. Unlike POTUS, right? President of the United States. This is WOTUS, waters of the United States. You may have seen it if you're reading the popular press. You may have seen it referred to as that, or Waters of the United States rule, or Clean Water Rule, or Wetland Rule. It goes by a number of names, but it's all the same thing. It's the rule that EPA promulgated as a draft rule in 2014, got 1 million or so comments, most of them negative, then promulgated the rule as a final rule in 2015, and subject to a lot of challenges, and has now stayed. This was the rule that was supposed to clarify that middle ground between an area of land that's right next to what is clearly a navigable water, in an area of land that is the prairie pothole that's sort of out there in the middle of nowhere without any hydrological, without any water connection to a navigable water, that middle ground. This rule was supposed to clarify it, didn't exactly do that.
So one of the participants asked a really interesting question here, because we've been talking about draining the wetland to use it for either farming or non-farming activities.
Right.
But what happens if you go the other way? So you decide to build a pond or expand the area for irrigation water storage or the like. Would that be considered a normal farming activity? Or if not, what are the circumstances it might be?
Well, there are specific exemptions that deal with the construction and maintenance of farm ponds or stock ponds or irrigation ditches, and so or maintaining a drainage ditch, because sometimes you're in there and you're digging in those areas, and there might be some fallback, some soil that falls into the area, soil that falls into the wetland. And so again, I think if you could point to the rationale for construction of that it is a farm pond or it is a stock pond, and what you're doing is you're building it or you're maintaining it, then it would be exempt. If you're expanding it significantly, that may cause some issues. That may raise some issues, but of an existing pond. The agency might make a determination that it's not maintenance of the pond, it's expansion. But the counter argument is it's simply exempt construction, and again, there's a rationale for the construction, and it should be exempt.
Now, you say here that the WOTUS rule states that no additional permitting is on agriculture is required, right. And I'm kind of have the idea that means that if you have the permit, you're great, but if you don't, you're going to get hammered in some way or another.
Well, yeah. Right, and maybe I need to clarify the language in the slide, because really what EPA said, the big response to the proposed rule was, this is a gigantic expansion. This is a gigantic expansion of your jurisdiction, EPA, and a number of agricultural groups and farm organizations made that argument. In response, in the final rule, EPA said, no, we are not imposing any additional strictures on you. We're not expanding our jurisdiction. Now, again, some disagree with that, and they point to some specific language in the rule that would at least potentially expand EPA's jurisdiction over certain types of ditches. But EPA said it wasn't their intent to narrow the exemptions under the statute. Now,
if you could talk a little bit about the penalties that apply, that's helpful to be thinking about in the context of the risk balancing.
Yeah, well, Mike, let me first ask you, what do you? I mean, you see the penalties there; they look pretty draconian, and they are on the slide. But just to step back a minute, what's your methodology for calculating risk before we talk about specific penalties?
So, as you could tell from my kind of comments a moment ago of the logic gate, okay, navigable water, yes, no, that kind of thing. I tend to things in a somewhat organized way. And when I'm looking at a way of thinking about risk, I do have a methodology. And the first thing I look at is, what are the chances that I'm wrong on a particular topic? And so we've talked a lot about the ambiguities and the like, and that rarely is there a situation where you're going to be 100% wrong. Occasionally you have situations where you're going to be 100% right. There's zero chance of being wrong. So I look at first allocating some risk associated with wrong on the law. And then the second, I look at what's the chances that I'll get caught, that a regulator will raise the issue, a next door neighbor will raise the issue. And sometimes it happens because there is political change that's going on. Sometimes it happens because you have right now Flint, Michigan, where there's a huge focus on the quality of water, and that's not just obviously in or near Flint, it's across the United States. People are really focusing on it, and appropriately so. And that means that the chances of someone saying, hey, wait a minute, why is the water coming off this land looking different than the pure stream that I remember when I was a kid? And that increases the chances that somebody would complain about it. Then I multiply that percentage times the damages, which are listed out here, and I look at my own client's attorney's fees, how much will it cost to defend. I look at whether there's an attorney fee shifting contract or statute, which means that if you lose, in some cases even a small amount, you're required to pay the other side's fees, and in some cases even more than the other side's fees, based on what's called a lodestar amount. And then I look at what are the risks of doing nothing. I look at the public relations risk. I look at the customer relations risk, which I'd say in today's farming and agricultural world is a very significant thing. You see articles in the New York Times about retailers looking at good farming practices all the way through their supply chain down to the farm. I look at the employee relations risk and those types of things, and then I kind of put that into a bucket to make a decision about which route to go and how to minimize that risk profile.
Well, that makes sense.
Somewhat analytic way of doing it.
No, I think that makes sense. The only thing that gives me pause there as a former Justice Department attorney is the risk that you'll get caught, because in a regulatory affairs situation, we tend to assume that you're going to get caught. So that there'll be a neighbor that is a whistleblower, or a lot of EPA enforcement actions arise out of whistleblowers, for example. So it's certainly a fair calculus and something to consider, but more often than not, even if you don't end up with an enforcement action right away, it probably makes sense to come into compliance going forward.
Agreed. So is there a point where the penalties start to either decline or drop off through? There is a
statute. There's a 5-year statute of limitations under the Clean Water for civil enforcement actions under the Clean Water Act, and it's 5 years from the time a claim accrued. The interesting thing with wetlands violations is, as the slide mentions, a wetland violation continues until the fill is removed, which means it is a continuing violation. So if you unlawfully filled a wetland 10 years ago, then you're still going to be responsible for 5 years of penalties, because unless you've removed the fill from the wetland.
So you can't make a change and then hold your fingers for 5 years. In other words, at least
you can't. Yeah, you right. I mean, you can't make it. You can't make a change and then hold your fingers for 5 years, or cross your fingers for 5 years, unless you actually physically take the material out of the wetland. Right.
Now, I had asked as we were preparing to list out the traps for the unwary. Can you explain these?
Sure. I don't know if they're self-evident, but we'll talk about them for just a moment. I think the most important thing to realize here is that this is a complex area of the law, and you can't just go out and drain a swamp on your property just because you've always done it in the past. It's not to say that you can't do it, but consider the consequences of the actions first. That is absolutely key. The second one, and we talked about this a little bit earlier, relying on the National Wetlands Inventory Map. There is no easy spot where you can go and identify whether a pond on your property is regulated under the Clean Water Act. So don't think that there's some sort of an easy spot to take a look at there. The third one, assuming that any farm activity is exempt as normal farming. Again, it may well be, but it goes back in some respects to this first point. Consider those consequences and make sure you carefully consider the exemptions. Don't just assume that your activities are going to be exempt. And then finally, as we've discussed a bit, don't ignore state and local laws, as my client who got the local cease and desist order did. Just because a wetland isn't regulated under the Clean Water Act doesn't mean that you can fill it or drain it.
And then a corollary to that is, what are the 5 steps that I should take to prevent risk?
and these really are a corollary, and it goes back to, I hope it doesn't sound too self-serving, but as I said, this is a complex area, and you really ought to seek technical and legal assistance unless you're absolutely certain that your activity is exempt. And I think that's the case even if a single regulator tells you, oh yes, you're fine, because you can't rely upon just a single person in a district office somewhere saying, sure, go ahead. It's a little more complex than that. Again, related to that, carefully compare those activities to your exemptions, to the statutory exemptions. And the third point is, really the third and fourth points are points that you ought to discuss with professional and professional legal and technical advisors. It may be that you would actually want to go out and do your own audit of a wetland, and by auditing I mean go out and take a look to get an idea of how often that particular property is wet during the year, whether there are aquatic plants or plants that tend to grow in aquatic media growing in and around that area. And it is the Army Corps of Engineers will do that. They'll charge you, but they will do that for you, and they will make a jurisdictional determination if you're not sure and if you ask them. Of course, your own technical and legal advisors may disagree with the Corps' jurisdictional determination, which is why I wouldn't just say that it's something that you want to do as a matter of course. You want to consider that carefully. And then finally, as we've discussed before, don't forget about state and local regulations. It's a corollary to a trap for the unwary.
A couple of quick questions just in following up about the wetlands audit. It sounds like that's something that a person could do on their own, just kind of walk in their land to make that kind of determination. But are there consultants that do those for you?
There are, and I wouldn't try to do it on your own because it is, first of all, it's more persuasive to a regulator if you have someone who is experienced in making those types of determinations. And yes, there are consultants that do that and that do it all the time and do it well. And again, it's not terribly expensive, and it can be good insurance down the road if there are questions going forward about whether or not the area was regulated.
So I know that sometimes we'll recommend clients do audits, but to call their lawyer first to get a letter requesting that to the lawyer so that we can cover the attorney-client privilege.
Definitely, that's absolutely correct. And in fact, the lawyer may, in a circumstance like that, may want to retain the consultant, and in a way that would allow the lawyer to assist that lawyer in providing legal advice to the client. Of course, the actual, the photographs that the consultant takes and the types of plants that are actually on the area, that's factual information that isn't going to be privileged. But mental impressions with respect and conclusions regarding the audit, it may make sense to have a lawyer involved if you're concerned about the privilege.
And to do that before the audit is conducted.
And to do that before the audit, right. The best way to do that is to actually have the lawyer retain the consultant rather than have the client retain the consultant directly, because at that point, the consultant is assisting the lawyer in providing legal advice to the client rather than just being retained by the client. If the consultant's retained by the client, it's harder to make an argument about to make an argument that information is privileged.
So, quick question before we go here. We have a link to a summary of the EPA regulations that you had put together, but somebody else asked a question about what constitutes normal farming and what doesn't. Are there places that somebody can go to get those types of definitions?
There are specific provisions in the Clean Water Act where people can go to look at those, look at that language. If you want, let me find it here in my notes, and I can give you some citations. There are also some regulations that construe that as well. If people are interested, the exemptions are in Section 404F, as in Frank, of the Clean Water Act, and you can find the exemptions discussed more fully in the regulations at 40 Code of Federal Regulations 232.3 and 232.4. And sorry, and 33 CFR 323.4.
Yeah, and a quick Google search can get folks to those.
Quick Google search will give you that, right. If you look at farming exemptions under the Clean Water Act, you'll find those citations on
Terrific.
Google.
Well,
right.
Thad,
right.
Thank you so much. This has really been
Oh,
a
it's
great
my pleasure, Mike.
program.
Thank you.
And for the participants, a couple of pieces of information as we wrap up today. First, there is CLE credit in all the key jurisdictions that people have signed in for. And if you would like, please just return the sign-in sheet that was provided with yesterday's reminder, and you'll receive a CLE certificate that you can retain for your use later on. And that includes, again, all the key jurisdictions managed through Dorsey's continuing education group, known as Dorsey University. Also, I'd recommend to people listening in that you go to the newly revised and very beautiful Dorsey website. We have pages on each of our key practice areas. You see here a link to the page of the Dorsey and Whitney Food and Agribusiness website section, and in that on that page you see a blue newsletter sign up button, and if you'd like to learn more information on this and other food and agribusiness related topics, or to receive invitations to upcoming programs, please go to the newsletter sign up page and you can sign up for whichever of the many Dorsey and Whitney client alerts and announcements are applicable to your work and to your company. We do have a couple of programs that are coming up. We just recently gave a presentation to the National Society of Accountants for Cooperatives on mergers and acquisitions in agribusiness and cooperatives, and we will be redoing that program with one of our clients who has been through 3 different agricultural mergers, 2 of which that worked and 1 that didn't. And there are a lot of learning points to be taken from that. So we encourage you to participate in the merger and acquisition webinar that will be coming up in the next couple of months, and again announced as this one was through the Dorsey newsletter system. Second, we have a program on tech law in agribusiness, which will be offered in a web format, very similar to some programs that we've done in our Minneapolis and Des Moines offices. It's fascinating to me how quickly over the last couple of years technology firms have begun to understand the use of drones, of measuring devices and the like that can happen in agribusiness. And we're seeing a lot of client interest in how these new technologies are regulated in agribusiness and the areas that can cause risk to companies. And just briefly, a couple of pieces of information about the kind of legal work that we do serving the food and agribusiness industry. As you'll see on the website here, and in addition on the newsletters as you receive them, each of our practice areas, the key technical specialty practice areas, have representatives that are part of the food and agribusiness industry group. So whether that includes corporate and employment law like myself, people who do environmental law like Thad, food safety, immigration, intellectual property, real estate, all kinds of different issues are encompassed within the food and agribusiness area, where we have people who've spent their lives focusing their practices in certain key areas, but also have understanding of the unique aspects of that of their technical area in the context of the food and agribusiness world. And then I wanted to include a brief summary of the cooperative practice because it's often a corollary between food and agribusiness and delivering that through the corporate structure of a cooperative. Dorsey is unique in the country among major law firms to have a very strong, robust practice representing cooperatives in their everything from their corporate governance to contracts, banking regulations, regulatory affairs, international joint ventures, the whole 9 yards. So for those who are affiliated with a cooperative, I encourage you to, again, go to the newsletter sign-up page and to sign up for the co-ops practice summary as well. And then finally, thank you again for participating in today's program. You will receive a survey form shortly after the program. I strongly encourage every participant to complete a survey. We've set it up so it's very quick and easy to do. It will literally take you less than 2 minutes, but it's quite helpful to us to improve our programs. We're very grateful for your participation and your feedback on the program. And then last but not least, very helpful to us to have your topic suggestions for future webcasts. We'd love to hear from you on any issues that you think would be helpful, and in particular helpful delivered through the web format. So with that, thank you. Again, on behalf of Dorsey and Whitney and our Food and Agribusiness Practice Group, we're very grateful that you could participate in today's program.